learners, I am Dr. Lata Rani, Associate Professor and Program Anchor of Banking, Financial Service and Insurance Department at Delhi Skill and Entrepreneurship University. In this today's session, we are going to learn consideration. Very important topic of Business Law BCOC 133. The learning outcomes of today's session is consideration. As to what it is, you would be able to know the nature of consideration. If there is any stranger to the contract, how consideration is going to affect the same. We would be dealing with the first topic first, that is, what is a consideration? How to define the consideration in a legal jargon, and suitable example would be given to illustrate the consideration in a simple, lucid manner. Let us start. Consideration is the price of a contract, and it can be the right, interest or responsibility. So, price of the contract is known as consideration, because we know if there is no consideration, there is no contract. So, according to section 2 subsection D of Indian Contract Act 1872, when at the desire of the promisor, promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration from the promise. So, if a promisor is saying to do something or not to do something and paying a price for the same, that is part of consideration. So, definition is divided into three parts. Number one, a person has done something or he has been stopped not to do that thing. So, that has been done. So, this is consideration of past nature. Or second, does something or abstains from doing something, that is present consideration. Third, promises to do something or to abstain from doing that thing, that is future consideration. So, consideration may be past, present or future, and the price for that particular action or abstinence is known as consideration. Let us take an example. A offers to sell his car to B for a sum of rupees 1 lakh. This 1 lakh is a consideration. B accepts the offer. In this contract, A is a promisor who is offerer, and it is a desire to sell his car for rupees 1 lakh, and B is taking and availing that offer. He is a promisee, and on the desire of A, he is purchasing the car for rupees 1 lakh. So, consideration for A's promise is rupees 1 lakh, while the consideration for B is the car. So, both are agreeing and accepting the promise. A is offerer, so is a promisor. B is an offeree, so is the promisee. So, both are at the consideration level. A will get rupees 1 lakh, that is the consideration of A. B will get a car, and that is the consideration of B. Consideration and legality of the object. Now, any legal contract stipulates that consideration must be there. The legality of the object in contract law stipulates that the consideration and the object of a contract are considered legal except under these situations. Number one, when they are specifically forbidden by law. So, if somebody is giving you huge amount to make you part of any contract that is prohibited, it is illegal. So, simply you cannot say that amount was present, so contract is valid. So, if you are being indulging in a drug business and you are offering that I will give you 10 lakh if you supply this particular drug to that party. So, no matter this 10 lakh is available in the contract, consideration is available, but it is forbidden by the law. So, that will not make a contract legal. So, legality has to be there where there is a consideration, but that is not applicable to all these situations. So, exceptions of the consideration and the rule of consideration are when those actions are forbidden by the law, number one. Number two, if they are fraudulent in nature, the intention is to cheat someone, deceive someone, and even if it is a consideration based, it is illegal. Third, the nature of the object and the consideration is such that it defeats the purpose of the law. That means you are violating the legal provisions. You are breaking the legal aspect. In that case also, this is illegal. Number four, this kind of contract involves injury, harm to a person, to a property, or both. In that scenario, it is again illegal. Or any action that is considered as immoral by the court of law. And last but not the least, if they are against public policy. Public policy means the policy which is in favor of a public. So, if you are opening a factory where it is written that you cannot open because chimneys or the pollution will cause a hazardous health impact to the people. So, your factory should be in the area where the population is either less than 10,000, 5,000. In those areas, those factories which produce a hazardous impact may be opened, and if you are opening your business with a consideration in those areas which is against and notified as per the public policy, then this kind of contract is illegal. So, just like if you are smoking at a public place, you are violating the public policy. So, as a smoker, you can have no right to smoke at a public place. So, even if you are paying for the cigarette, you are actually taking and getting it and you are using it at a public platform, this is against the public policy. So, no matter if consideration is present in all these 6 scenarios, it will not make the object of the contract legal. Lawful object and lawful consideration, that is the purpose of section 23. The purpose or consideration of any agreement is absolutely valid unless it falls under these categories. That is forbidden by law, number 1, consideration in violation of the law, number 2, deceptive thoughts or cheating purpose, number 3, consideration or object which includes an injury to a person, to a property, to a willpower, to a reputation, number 4, if court thinks it is immoral, number 5, or any consideration with an intention to violate the legal aspect of public policy, number 6, and last but not the least, if you are trading with an enemy, alien enemy. So, where countries' relationship are disturbed, in that scenario you cannot deal with particular country or particular person of that country, and if you are trading it with that alien enemy, then it is illegal. forbidden by law. That means this is something if you are doing it in an illegitimate manner. If the purpose of the contract or the consideration of the contract is legally prohibited, then there is no legal consideration or objection. Then they may become naturally illegitimate. Therefore, such an agreement will be no longer applicable. Illegal consideration of an object includes any actions that are directly punishable by law. This includes those who have legitimate authority over the existence of laws and regulations. So, if for example, a licensed Department of Forestry for cutting local grass, department officials told him that he could not pass such an interest to anyone else, but the forest law does not have that law. So, A sold his interest in B and contract was held legally. So, in that case, this is done under the provisions and the norms. Violation of the provision of law. This means that if any contractor tries to defeat the purpose of the law, if the court finds that the real purpose of the parties to the agreement is circumvent to the provision of law, they will set aside that contract. Let's take an example. A and B enter into an agreement where A is a debtor and B will not agree to a limit. This, however, is done to defeat the purpose of Restriction Act. So, the courts may decide the contract as null and void because of something illegal, right. So, B is not agreeing to a limit, so it means there is no consent, there is no consideration. Deceptive thoughts or something. A legitimate consideration or an object can never be deceptive, but any agreements entered into this kind of presumption of illicit fraud, material misconduct are part and parcel of deceptive thoughts. So, where you have an intention to cheat someone, to deceive someone, to conceal the contract, then all this falls under deceptive thoughts. Let's take an example. Suppose that A decides to sell goods to B and smuggles them out of the country. Now, this is a false work as it is useless. Now, B cannot reimburse under the law if A does not fulfill his promise. So, these kinds of deceptive thoughts will make the contract void. Injury to a person or a property. Yes, when the intention is such where you are causing an harassment of any level, whether it is physical, mental or both, for the intention to harm a person or his or her property, then that thing falls under this section. So, in this case the word injury refers to the acts of violence, harassment, coercion, assault which is belonging to that contract to harm a person or to harm his or her property or both. Let's take an example. X borrowed rupees 1000 from Y and made a bond promising to work for Y without pay for 2 years, and in that event of failure to allow to pay high interest on the principal amount, the contract was held in vain as it involved the injury of someone in the contract, right. So, when you are injuring someone in the contract, it is void, it is illegal. The court considers it immoral. Yes, in certain scenarios, court takes out and passes the judgment that it is immoral. Let's take an example of Supreme Court, where Supreme Court cited certain agreements in which consideration or object was immoral. If you are promising someone of marriage for a consideration, that I'll marry you if you give me this amount, this is immoral. Or contract for sale of a goods for the prostitute to continue her work, again it is immoral. Or any contract which is facilitating divorce, future settlement agreements, again court considers it as immoral. Let's take an example. A good example of an agreement which facilitates divorce is when person X gives Y that Y with a promise that Y will divorce Z and later marry X. However, if Y does not separate from Z, it cannot continue legal action against him. Why refund? The very nature of the contract is immoral. That somebody is actually being ensured, you file a divorce from the Z and marry Mr. X or Miss X. So this kind of contract is null and void. So you are taking the consideration for such contract which court feels it is immoral, it should not happen. Contrary to public policy. Anything that harms the public interest, that is against the welfare of the community, or that is against the social community projects, community development, comes under this category. However, it is not possible to provide a complete list of assumptions against public policy, because it varies from time to time. So, for example, if your particular company prohibits any social project under the NGO, so that project is to distribute the food to the needy, and if your company creates a contract with that NGO to stop that work with a consideration, it is against public policy. So, public policy is actually created for the welfare, for the betterment of people at large. If that is contrary, then in that case it is illegal and it is void. Next is trading with enemy. Any agreement with an unknown enemy or known enemy during the war without an Indian government license is invalid, because that is violating the civil policy of the law. The proclamation of war brings a ban on the international trade. That bans the international relationship, that bans the international contracts with the citizens of the enemy country. The very nature of the war is the crippling trade of the enemy world. So, if you are dealing, trading, contracting or initiating business dealings with the aligned enemy, where the relationship between two countries and their ambassadors and political relationship are disturbed, are not stable, then in that case it causes the violation of civil policy. So, if you trade with the consideration, it will be part of illegal contract. Next is stranger to a contract. If a person who is not a party to the contract, such party is known as stranger to the contract. There is a cardinal principle of law that only a party to a contract can sue. But if a person is not a party to the contract, he cannot sue even if contract is for his benefit. So, in order to create a legal relationship, privity of contract, that is contractual relationship, is mandatory. A contract cannot confer any right or nor impose any liability upon a person who is not a party to it. So, stranger to a contract is basically a contract which is created between two parties who have agreed on certain terms and conditions. For example, A agrees with B to give rupees 500 to C. C cannot file a suit against A to recover rupees 500 as there is no contract between A and C. Contract is just between A and B. So, here in this case, C is a stranger to the contract. So, stranger to the contract is not having any rights to be part of the contract, even though this contract is meant for C. So, A agree that he will give amount of rupees 500 to C, but C has not a right to file an action against A, because the contract is between A and B, not A and C. We have to see what is the difference between stranger to a consideration or a stranger to a contract. Let's see, a stranger to a consideration is actually a party to the contract, but the consideration is given by the third person. That means he is very much integral part of the contract. But in terms of consideration, somebody third party has to pay off. Whereas stranger to a contract is not at all a party. The contract is between the main party. So, like I have given example in this slide, where A agrees with B to give 500 to C. So, accordingly A and B has entered into a contract. So, eventually A and B are obliged to perform the mentioning part of obligation written under contract, and C is a stranger to a contract, because contract has not been created between A, B and C. Rather, it is a contract between A and B. So, C is a party who is a stranger to a contract. So, stranger to a consideration can sue, whereas stranger to a contract cannot sue. So, when we talk of stranger to a contract and stranger to a consideration, we must know how that is going to create a contract. So, in this whole scenario, Indian law says a person may not have himself given any consideration, but he can enforce a contract if he is only a party to the contract. So, when we talk of a stranger to a consideration, yes, the right is given to a party that he can have a sue right to sue and be sued. Whereas, in the stranger to contract, that party is not a part of the main contract. So, he does not have a right to sue and be sued. So, when we talk of the legal examples, let us understand. Consideration must move at the desire of promisor only. So, if it is promisor and promisee who are part of the contract, it must be moving from the promisor to the promisee. It can never move from a promisee to the promisor. So, when we are dealing with the stranger to the consideration, we must know that it is an integral part of the contract. So, as a stranger, even if third party is supposed to make the payment, he can have a claiming right. Whereas, in the stranger to contract, there is no claiming right, which talks about meaning of privity. So, privity means relationship between two parties. So, as such, in the stranger to contract, there is no legal relationship between the parties. So, privity principle, the principle of privity is not established under stranger of consideration. Let's take an example of Kedarnath Bhatterjee versus Gauri Muhammad. That case has happened in 1887. What was this case? That there was the word called section 2 subsection D of Indian Contract Act, which gives a right concept of promissory estoppel. It came through a situation where on the promise made by the promisor, that has changed his legal position on believing that such promise in this case will be bounded by promisor. Then it was not done. In that case, it is basically strange to the contract, right? So, we must know under the English law as well as Indian law, we must know stranger to consideration can sue. So, take the example of Dutton versus Poole. That case has happened in 1678, and this case was held that former precedent was set and stranger to consideration cannot sue under the English law, as there is no involvement of other person either as a contract or be as a consideration. So, in that case it is not fulfilled whether the agreement was created between Dutton and Poole. So, when the court believes there is a stranger who is unable to enter into the contract, in that case that plea will be taken up in a resigning form. So, stranger to consideration and a stranger to contract must be understood from the angle of the legal aspect. Stranger to consideration is actually a consideration being offered by third party, and all are part of the contract. So, in that case it is very much valid. So, you have read in a newspaper there was one advertisement. Let us take an example. Somebody has advertised, my son is missing, somebody who will actually give the information about my son will be given 1000 rupees. So, eventually you have seen that, and another party, somebody else also have given an information, if this boy would be found out by the relative, by the third party, I would give 10,000. So, you found that boy, you went to that home and you took out your 1000 rupees. With the same advertisement, you came to know that somebody has already offered 10,000 for the same boy missed. So, this is third party, that mama or the relative of that boy has offered 10,000. In that case, you are very much eligible and liable to get those 10,000 rupees, even if it is a stranger to a consideration. So, third party is paying it. But however, stranger to contract, yes, there is no establishing relationship between the parties as a promisor with the promisee, as an offerer to the offeree. In that scenario, it is not eligible to be part of that contract, and so the consideration. You cannot claim the consideration because of non-existence of your relationship with that perspective of main parties, that is promisor and promisee. I hope it is clear. Thank you so much. Keep learning, keep enjoying, keep reading.